welcome to Free Frank, and thanks to everyone for making their way down here, and especially if we're one of the ones that had to have patience with the shift from one room to another. Thank you for following us around, and I hope with actually the lights working in this room, we'll find it more comfortable for everybody. I'm very pleased to see that some people from the NGO, from the law firms, from government agencies, and especially from the international community signed up for the program here this afternoon. Welcome to everybody who's already here, and please bear with us if a few more people join us late, because we did have quite a long list of signed up, but my own car driver that brought me down from Penn Station said they had a huge line of requests for people to come down here this afternoon, so there may be a delay with anybody who's waiting at least for a car. My name is Grisez. I'm Special Counsel for Public Service in Free Frank's Washington, D.C. office. In that capacity, I manage the pro bono program there, which includes supervising all the immigration matters, both for unaccompanied minors and for adults as well. I've personally had the privilege of representing a number of children in proceedings, some of them in Washington, but more as a volunteer at ProBar on the Mexican border in Harlingen, Texas. My firm operates a summer associate internship program there, where we go down every summer and represent detained individuals in their proceedings. And not this summer, but very frequently in the past years, it happens that we've represented children, and it's been quite an eye-opener to see not only what the children have experienced before they've come, but some of the things that they continue to experience while they're here and are actually in custody and pursuing reunification at the same time as they're facing the legal issues in their cases themselves. I know through our contacts at ProBar about the huge influx in the of children coming across the border in recent months, and so we are very happy to be hosting this dialogue today and welcoming people here to talk about this important issue. The New York legal community, everybody knows, has been really stellar on immigration-related issues. From the New York Immigration Coalition to the Katzman Study Group to the City Bar, and a number of organizations in this room, whether working on direct rep or in the policy side, the interest in immigration-related issues, and especially the critical need for pro bono services for immigration, is great in this community. So not a better forum to host this conversation about children and children's issues here today. A few words for the people who are here and may be familiar with CMS, the Center for Migration Studies, and I have to, because I'm a brand new board member at CMS, I only have one board meeting under my belt, so I have to still look at my cheat sheet for the facts and figures. Center for Migration Studies is a New York-based educational institute devoted to the study of international migration, to the promotion of understanding between immigrants and receiving communities, and to public policies that safeguard the dignity and rights of migrants, refugees, and newcomers. Now here's where I really have to look at the dates. CMS was established in '64 and incorporated in 1969 by the Congregation of the Missionaries of St. Charles, Scalabrinians, which is an order of Catholic priests dedicated to working with migrants. Now here's the place where I don't need the cheat sheet. With one board meeting and a tiny little orientation, I have been extremely impressed with the work that CMS is doing, and I didn't know of CMS much before I was asked to join the board, but the scholarly publications, the programming, and in particular the archives, phenomenal set of archives, which actually have a tremendous collection of immigration-related materials from the mid-19th century up until the present. The archives are a treasure trove, and I hope, even though everybody's here to talk about unaccompanied kids, that as a result of this discussion, people will have the opportunity to learn a little more about CMS and what it has to offer as well. So I'm going to start now by introducing you to Don Kerwin, the Executive Director of CMS, and he's going to moderate the discussion today. I've served with Don for many years on the ABA Commission on Immigration, and in his previous lives worked with him in Washington when he was at the Migration Policy Institute, and before that the Executive Director of Clinic. the Catholic Legal Immigration Network. So Don and I continue to keep each other's company, and with that, I'm going to turn the program over to Don and let him introduce the other speakers and the discussion. So welcome.
Thank you, Karen. Thanks very much. What Karen doesn't tell you is that we both got kicked off the ABA at the same year. So, of course, I immediately scooped her up as a board member for Center for Migration Studies. So I wanted to thank Karen for hosting and Fried Frank for hosting this event, and really for their leadership over the years, both Karen and the great Bob Juseum, who walks these halls as well, in providing counsel for low-income immigrants and also, for unaccompanied minors. Before I introduce our speakers, though, Karen knows darn well that I'm going to say a few things about this issue, and this what I think is a significant humanitarian crisis at this point. I think, when you address the issue of unaccompanied minors, you're dealing with kind of a misconception that children don't need special protection and attention. We know better, but others don't. There's the sense that, they're embedded in families, they're embedded in communities that'll care for them. And children can kind of be somewhat of an afterthought even. Some think that they're the very last people that are going to be endangered in war or conflict or economic hardship or instability, or just as a result of kind of the normal social problems. And yet exactly the opposite is true. The International Refugee Committee has pointed out that there's 30 armed conflicts right now raging around the world, and children are suffering disproportionately as a result of them. 20 million children have been uprooted and displaced. And we've been very alarmed by the surge of unaccompanied minors heading to the United States and crossing the US-Mexico border, and the reports of growing numbers elsewhere. It's interesting the number of people that have contacted me and said, this is an issue in Europe, it's an issue in many other places as well. I'm just actually returning from the US-Mexico border myself, and I've been participating in a process down there involving law enforcement, labor, business, the Border Patrol, NGOs, faith-based groups, and others to try to reconceptualize the US-Mexico border. An interesting process, needless to say. And it starts with looking at the border the way it is and imagining what it might look like 50 years from now, which is a kind of a leap of faith. You hope that it gets better. So how is the border? I think one of my most vivid memories of spending time on the border was when I was part of a delegation and we were speaking to kids who had been picked up by the Border Patrol. And there was this one kid kind of speaking for the others who was, just weeping copiously, not because he was separated from his family or because he was alone and detained, but because he felt that he failed his family and he felt that he was going to be returning empty-handed. Another time, in another place, we were speaking to kids in Mexico at these casas de huéspedes, these kind of guest houses, and there's bunk beds lined up in these places, maybe 10 bunk beds per small room, and the kids sleep 5 across, on the bunk bed, so 10 per bunk. There was one 16-year-old kid that I was talking to with his young brother. And this kid was actually, he was headed to Northern Virginia to work. And I actually live in Northern Virginia, which was quite an eye-opener to me, and was not just coming as a 16-year-old, but was caring for his little brother as well. So you have these children bearing these terrible kind of adult-sized, responsibilities and burdens, and often fleeing situations that nobody, much less a child, should be exposed to. We've established in this country, and of course in Mexico and our relations with other countries, some very complicated systems to carry out our laws vis-a-vis unaccompanied minors. In the US, just counting the government players, and I know I'm going to miss some, but you have DHS, Department of Homeland Security, Office of Refugee Resettlement, Department of State, Executive Office for Immigration Review, the immigration courts. You have state courts involved, you have city officials involved. You have others, and I'm sure there's other government people, maybe even in this room, who I'm missing. And you also have this tremendous network of non-governmental organizations, like many of you represented here. Mexico, of course, has shelters for kids. They have protection officers to accompany them through the repatriation process. And as we know, this population has been a particular priority for the outgoing First Lady of Mexico. The more you look at these systems, and it's been great progress in some ways, the more you realize that if children are left alone and unprotected at any point in this process, even for 15 minutes, they're at risk. You better not repatriate them, for example, without strong protections in place, or they'll be recruited by drug cartels, or they'll be victimized by criminals in other ways. And yet, you have thousands of kids now running the gauntlet of cartels, gangs, smugglers, perilous crossing routes, and they're risking their lives to come to what? You know, a very weak kind of economic situation, which I think is indicates the level of the crisis that we're seeing. So what you'd hope for in rethinking about the border is you'd hope for a border and an international system of development and protection where this wasn't taking place, you know, but the fact is that it is. The children, and they're not always treated very well either. These children are held in cold, you know, air-conditioned cells for hours on end, and at best given dirty blankets and insufficient food. So there's lots of work to do. I know this for a fact. I've been there. I've been to the border maybe 60 times myself, and you know, have seen these places. Before I continue to preach, I wanted to get a little bit more policy-oriented for just a second. And I wanted to commend to you, and I have copies if you're interested, a draft document that UNICEF has prepared and shared for us for this meeting in anticipation of this gathering. And it looks at the many human rights standards, particularly the Convention on the Rights of the Child, and sets forth the guidelines that should govern repatriation of unaccompanied minors. UNICEF, IOM, and the United Nations High Commissioner for Refugees has been particularly focused on the repatriation of Afghani children from Europe. That's the genesis and the cause of this document, but it has much broader application. So let me just give you a few quick highlights. First, unaccompanied minors must be treated as children first and migrants second. A very powerful principle, I think. Second, the four guiding principles of the Convention on the Rights of the Child have to govern the repatriation process. They are non-discrimination, including no stigmatization of children. And I think that's a big one, right? I mean, these kids are stigmatized. We all know it. Acting in the best interests of the child, honoring the right to life, to survival, and to development, and honoring the right to participate. The draft stipulates that best interest determinations can't take place without access to our territory. And this is a huge issue in kind of the refugee protection system now, and the child protection system. People can't reach protection. And due process has to be assured through appointment of counsel and through appointment of guardians. It also stipulates that any policies or practices have to be gender sensitive and have to take into account the gender-related causes of unaccompanied child migration. Repatriation can only be used as a protection measure, not as a punishment, and the mechanisms used have to be safe and child-sensitive. The children must not be detained. The right to seek asylum has to be safeguarded, and durable solutions have to be sought. And what are those? I think we know: family reunification in the country of origin or destination, integration in the country of destination via foster care or child protection systems, or rarely resettlement in a third country. They're looking for people to look at these documents and to comment on them, and I would encourage all of you experts, if you're interested, to do that, and I have copies for you if you'd like to take them with you. We have superb speakers and superb respondents today. Keynote speaker today is Wendy Young. Wendy has been a leading advocate for refugee women and children for as long as I've known her, and I've known her since July 20th, 1992. It was that memorable, right? Because it was my first day of work at the Catholic Legal Immigration Network, and Wendy was my next door neighbor. At that time, she directed the U.S. Bishop's Immigration Policy Office, but she's also had leadership positions pretty much wherever she's gone. She was at La Raza for a period of time. She was at the Women's Commission for Refugee Women and Children. She was at UNHCR, the Washington rep there. And she worked for Senator Kennedy most recently. And she now heads Kids in Need of Defense, which was founded by Microsoft and Angelina Jolie. Microsoft, I've got to say, has proven to be a model of good corporate citizenship on this issue. devoting financial resources, but every other kind of resources you can possibly imagine, to hundreds of thousands of hours of staff time, their own capital, their own connections. And I must say that, Ms. Jolie and her husband have taken on, if you think about it, some of the most pressing, important humanitarian issues that we've seen in our lives, refugee issues, children's issues, the situation of the Gulf Coast post-Katrina, where they're doing terrific work, and others. And they've taken them on over the long term, a great sacrifice, and have made a real difference on these issues, as this agency has. KIND has been doing remarkable work in partnership with 125 firms, corporations, and other NGOs to represent these kids. It's inconceivable, folks, that due process could possibly be served, or that the government's interest in the best decisions in these cases could possibly be realized without legal counsel, without guardians, and without the kind of wraparound services that these children get. I remember the old days when, in courts, kids would come in and they would basically cry the whole time. That's what they would do. That's the way it used to be. So we're thrilled to have Wendy here. We're also delighted to have Judge Gabriel Videla, who adjudicates the cases of unaccompanied minors in his court docket. We're actually thrilled to have you, Judge, and thank you very much for joining us. There have been striking reforms in courts over the years, and we've asked Judge Videla to address these, the challenges that these cases present in court, how proceedings work, and anything else, that you'd like to discuss and respond to Wendy's presentation or what I've just said. And we're equally delighted, we hope, to have Wendy Claudio, who coordinates a full-service program for unaccompanied minors at Children's Village in Dobbs Ferry, although I know she had some problems getting here, so she may be coming later or maybe not. So we're going to ask Wendy to speak for 15 to 20 minutes, Judge Videla to speak for as long as he likes in response, and maybe 7 to 10 minutes. And then we'll open it up for discussion. Thank you.
Thank you, Don, and thank you, CMS, and thank you, Karen and Frank, for hosting this gathering. And I have to say, it's amazing to come to New York and look at this audience, and there are so many experts already sitting here. So I'm hoping that this will turn into a dialogue more than a presentation. And it's so in contrast to Washington, where our expertise is gathering people who know nothing to talk about how to address issues. Don't tell them I said that. But when Don mentioned when we were at the Catholic conference together, it sparked a memory. Don really joined the conference to address the Haitian refugee crisis at that time. It was a time when tens of thousands of Haitians were getting on boats and making that desperate voyage to the United States, and the response of the United States was less than adequate, shall we say. And as you may know, tens of thousands of people ended up being housed on Guantanamo Bay rather than in order to prevent them to making the mainland. What a lot of people don't realize is as that issue was sorted out, as we resolved the situation of people housed on Guantanamo Bay, at the end of the day there were two groups left on Guantanamo. One were HIV positive individuals, the other were unaccompanied children, which tells you, probably the two most vulnerable groups in that mix were the ones that were considered the most complicated, the hardest to resolve, and as a result, the most neglected. I like to start these presentations with a story, because I do think when we talk immigration, we tend to talk in numbers. We tend to talk about the Byzantine immigration laws that we all try to implement as best we can. What we forget sometimes is the human face behind it. But it was about a year ago, I actually visited the Baltimore Immigration Court, which was Judge Gabriel was presiding that day. And it was one of these chaotic juvenile dockets that Judge Videla knows quite well, with kids and their families milling around the room. And Judge Gabriel called the case, and up to the front walked a little 5-year-old Mexican girl with a young woman who didn't appear to be more than 18 or 19 herself. And the little girl was dressed in her Sunday best. She had this beautiful little red dress on, little Ugg boots, and she was clutching a doll. And she sat behind a respondent's table, not too dissimilar from this table, with the microphone, and her head came up to about here. And at that point, I didn't know who I felt more sorry for, Judge Gabriel or that little girl, because it was a master calendar hearing, so they were not getting to the merits of her case. But he was trying to check in with her and say, what's going on in your life? What came out was that she did not have a lawyer yet, and yet here she was in a very formal courtroom proceeding. Judge Gossard said, well, Kind is in the room, fortunately not myself, my staff attorney, and he pointed her out, and to make a long story short, we were able to obtain pro bono counsel for that young child, and many months later, she was very successful in winning special immigrant juvenile status, so she's being allowed to remain. But to me, that picture of that little girl at the front of the room, and actually as she left the room, because Judge Gossard said to her at that point, what's your baby doll's name? And she looked at him and said in Spanish, baby doll. So that is really, that really characterizes the day-to-day life of these children and what they go through when they're in deportation proceedings in the United States. But let me back up and talk about who are these kids. And again, I encourage any of you to interrupt me, raise your hand, ask a question, or add something if you'd like. But approximately 85% of the kids who come to the United States are from Central America, with the top sending country, usually Guatemala, sometimes El Salvador, Honduras, and then Mexico is next on the list. I often get asked, why isn't Mexico number one on the list? Well, the main reason for that is that most Mexican children are turned around at the border and are never allowed access into the United States. I'm going to put that issue aside and we can talk about that, because under legislation that passed in 2008, the Border Patrol is theoretically supposed to be screening Mexican children for protection concerns at the border, but that's a process that's being implemented on a very ad hoc basis at this point. Within KIND's program, we're currently working with children with 59 nationalities, so they do come from all over the world. The average age is 14, but the youngest child we work with is 2. Most of the kids, to qualify for the program, they have to be under age 18. Some of the kids do age up as we're working with them, and they may be 19 or 20. Roughly 75% of the children who arrive in the United States are boys, and 25% are girls. But I understand that statistic, strangely, is changing. In the context of this most recent influx, there seems to be a high percentage of girls, much higher than normal. And the age seems to be lower. There's a lot more kids under age 12 arriving, according to the Border Patrol. How do these kids get here? Basically, any way they can. These are kids who walk, they hitchhike, they jump trains, they fly, they're stowaways on boats. They are smuggled and they are trafficked in very large numbers. And they are very vulnerable, not only because of whatever happened in their home country that generated their flight to begin with, but as they traverse whatever landscape to get to the United States, they're very vulnerable to abuses. We see a lot of girls who've been subject to sexual violence along the way. Kids are robbed, they're beaten, they're harassed. So when they arrive here, they're often, frankly, not in very good shape. But there's a reason why they came. And one of the things I always say is that if a child is on their own in the world moving, that's a red flag that something is going on. There's got to be a reason for it. What we see are kids fleeing human rights abuses, girls fleeing female genital mutilation, child marriages. We see kids who are fleeing gang recruitment, especially out of Central America, and that's something that seems to be increasing and is actually fueling the recent influx. We see kids who are fleeing domestic violence in their home situation. So in other words, an adult is not only perhaps encouraging them to come to the United States, but is compelling them to come because they're trying to get out of a very unsafe household. We see kids fleeing economic deprivation and everything that carries for kids with very poor health, kids who have not had the benefit of education, countries where there's nothing really for that child to sustain either their childhood or their future. And we see a lot of kids who are actually traveling to join family who's already here. Sometimes people will say, well, then why is that child considered unaccompanied? Well, they're still in removal proceedings by themselves. Their case is not attached to someone else. And secondly, that family member who they may be traveling to join, while the Office of Refugee Resettlement may release the child into the custody of that person, doesn't necessarily have legal status with that child in many cases. It's not required to care for that child. So it can be a very tenuous family relationship. And often these are family members who the child hasn't seen for many, many years, even if it's a parent. So the family reunifications are extremely tricky at best. Children, when they arrive, are typically taken into the custody of the Border Patrol, as Dawn just mentioned, and under the law are supposed to be held for 48 hours or less. They're held in these holding stations, and as Don indicated, these are very inadequate conditions for children. They tend to be these rooms that are, as he said, very cold. There's no proper bedding, there's no proper food. The child may have been picked up with a group of adults. They may be in visual contact with those adults. It is a very frightening process for a child. At that point, because of changes to the law that took place as part of the Homeland Security Act of 2002, which created the Department of Homeland Security, we did a Hail Mary at that time. And we basically said to Congress, and it was literally the 12th hour before that bill went to the floor, look, there's a group that is currently being held by the then Immigration Naturalization Service. They're incredibly vulnerable. INS is acting as jailer, prosecutor, parent all at once. These are conflicting roles, and frankly, they're not doing a very good job of it. Can you break that program away? And we got a commitment to do that, care, custody, and placement of the children was transferred to the Office of Refugee Resettlement within the Department of Health and Human Services, which is where it's been launched ever since. So 48 hours after apprehension, the children are supposed to go to ORR. Again, a place where the recent influx is having tremendous impact. Because the kids are arriving at such high numbers so rapidly, we've seen a kind of a buildup of kids at the border. And literally, for a period of several months, ORR did not have a bed space to move that child to. So they were backing up at the Border Patrol stations and being held for much longer periods of time before then being transferred to ORR. Since ORR assumed custody of the kids, we have seen, I have to say, improvements in the program from the old days under INS, but it is far from a perfect world. INS at the time largely contracted space from county facilities, and these were typically juvenile jails. They did have a few facilities that were contracted out to generally for-profit agencies to operate. When ORR took jurisdiction over the program, they started to morph it into something new and different. And they moved generally in a direction of trying to identify more child-appropriate space. So kids are being held in group shelters, for example. They may be held in transitional homes. Some kids are held in secure facilities if there's some reason that they've been deemed to have to require that kind of setting. Some kids are held in therapeutic settings, and there is some long-term foster care available, particularly for younger kids or kids who appear to be likely to stay in custody for a very long period of time, or kids have some particular special needs. So it's a mix of programs. Frankly, I would say, having watched this over the years, I would like to see them move in even further of a direction where the kids are really held in the least restrictive setting possible and are held for the shortest period of time. And those are standards that actually are part of what's known as the Flores v. Reno lawsuit settlement agreement, which was 1997, I believe, which is when INS was sued for their care of unaccompanied children, and they're also codified in the Trafficking Victims Protection and Reauthorization Act. So a long ways still to go. And being an advocate at this point of time, I would like to see this challenge of this huge increase in numbers of kids arriving as actually an opportunity to look at how kids are housed and say, okay, clearly you can't keep them for very long because you got more kids in the pipeline coming across the border. And secondly, if you have to open up new space, let's make it appropriate space and look at things like foster care and small group home settings for these kids. So kids go to ORR. Kids are also at that time issued a notice to appear, which is basically the formal way of initiating their removal proceedings or their deportation proceedings, and they're required to appear in immigration court. Right now, jurisdiction for that case typically lodges at the court that's closest to where they're first picked up. But very often what you see is that when the child is moved to another location or released to another location, the venue changes, it should change. So what you see while the child's in custody is through a network of organizations that work with the children while they're in detention. There is an initial effort to provide those children with Know Your Rights presentations, with individual screenings, basically to prepare that child for that proceeding that's going to take place at some point. Historically then, about 65% of the kids were actually released from ORR custody to reunify with someone, typically a relative. That release rate is now up significantly, again because of the influx. We're now seeing an 80% release rate. On top of that, the number of days that kids are being held in custody has been reduced dramatically already. It's gone from an average of 72 days down to 42 days. And ORR's goal is to take it even lower, so that most kids are released within 2 to 3 weeks. Right there, I'm going to flag for you. Great that kids are being released, but we have to ensure that these kids are being released appropriately, and that there's a proper screening of the individual who is stepping forward to accept custody of that child. And I fear with this number of kids moving through the system that rapidly, that mistakes are being made. And I can tell you in Kind's work, even pre-influx, we saw some family reunifications that were shaky at best and in many situations abusive. And secondly, our concern is if kids are moving through the system, will the detained service providers who are funded to do the KYR that Wendy used through one-to-one screening, are they going to have time to really communicate to these children, to get them up to speed as best you can with the child, what's happening to you, and why you're perceiving it so important, and what you may be eligible for in terms of immigration relief in the United States. Once children are released, this is where Kind typically steps in. We generally don't work with the kids while they're in custody, with the exception of Newark, New Jersey, where we work with a small pool of detained children. What we do is try to match children with counsel post-release at their final destination site. And we do this in 2 ways. As Don said, we partner with major law firms and corporate legal departments, of which right now we have about 125. And we train about 4,200 private sector attorneys to take these children's cases. We also support a fellowship program where we place what we call Kind Fellows inside other organizations, such as Legal Aid Society, to provide direct representation to the children. And that's proven to be a very valuable tool because some of these cases are very, very complicated. And pro bono attorneys might not be the best source of representation for them, or the case is moving too quickly, or there's some other complexity in the case. But we've been very heartened by the response of the private sector. And I, for one, am very confident that we have only seen the tip of the iceberg in terms of our ability to access pro bono for these kids. Because the firms we work with are now coming back for more cases. They're now coming up with their own ideas of let's cluster asylum cases with us so that we can develop the in-house expertise, so that we can be really a good source for you, Kind, and for the children to take on these asylum cases. This, for me, is incredibly inspiring and encouraging. Having said that, another recommendation I would make is I think at some point the government should also step up and fund attorneys inside NGOs to provide direct representation, because again, there are some cases that are just not pro bono appropriate. I should say, by the way, that there's a statutory challenge in terms of the government providing government aid counsel, which is Section 292 of the Immigration Nationality Act, which basically states, and I'm paraphrasing, that individuals have the privilege of counsel, but at no expense to the government in their proceedings. There are now some interpretations out there that actually have reinterpreted that provision to say, well, it's not, basically what it's doing is not requiring the government to pay for counsel, but it doesn't necessarily preclude it either. And that's an interpretation that we're in full support of and are encouraging strategically to move forward on. Turning back to, and I kind of mixed things up here a little bit, but turning back to the influx and the question, why is this happening? I don't know if I know any more than a lot of the other people in this room, but I can tell you that the spikes, the most prominent spikes are being seen with Guatemalan and Salvadoran children. In conversations with the children, as well as NGOs that we work with at a local level in the sending countries, particularly in Guatemala, what we're hearing is that gang violence is a strong motivator for these kids, and that the violence is getting more extreme and more out of control than it was even before. And the kids being particularly vulnerable to recruitment by the gangs and trying to escape that. We've also heard that food insecurity issues in Guatemala is a motivator for Guatemalan kids. There was a lot of crop failure last year, and a lot of these kids come from rural agrarian communities. As I mentioned earlier, there seems to be a spike in the number of girls, and there seems to be a higher percentage of kids under age 12 than there was normally. What is also very clear to everyone is that there is very coordinated and extensive human smuggling going on, and that the smugglers are preying on these children. We are still trying to ascertain what are the kids being told to inspire them to link up with the smuggler. And I know that State Department in particular and the National Security Council have been very concerned about this and are looking at ways to basically spread information in sending communities that you don't want to send your child on this very perilous voyage to the United States, and what they're being promised, in fact, may very well be the opposite in terms of what they actually receive. Our referrals of kids are already up by 57%. That's not necessarily, kind of in 7 sites across the country. We're in LA, we're in Houston, Washington, Baltimore, Newark, New York, and Boston. That 57% increase is not necessarily consistent across our sites. And I can tell you New York is being very heavily impacted. And I am quite concerned right now that we are trying to meet a huge doubling in need with the exact same resources we had before. And it's not like we were not maxed out before this influx. So we are advocating very strongly, and this is difficult given the government budget environment and the economy generally, that new resources need to be introduced into the system. Just before the influx, we had actually just completed an assessment by an outside firm who did an extensive analysis of both government data as well as kind data that demonstrated that since 2009, the percentage of kids released from custody who were represented by counsel had increased from 27% to 51%, which is a huge improvement. But we're worried in the face of this many kids going through the system this quickly that we're going to lose that progress and perhaps even drop lower. I've touched on a lot of the things that we think need to happen in response to this, but I just want to go back to a few things just to tick them off. Again, let's move the care, custody, and placement program in the direction of the least secure setting possible and holding kids for the shortest period of time, but ensuring that we do effective checks on whoever presents themselves to accept custody of the child post-release. We need to ensure that services match the numbers and that services match the beds. And that's not only legal services, it's also social services. Because these kids, again, come to the United States with a lot of care. I think we need to cluster services more clearly at the first master calendar year. If kids are moving through custody too rapidly, we probably can't keep up with it. So the next kind of point of contact where we know the child will be at the immigration court. So think about having a pro bono program there available, or a kind fellow there available to tell the child, heads up, you really need a lawyer to get through this process. Think about having the child advocate program, which is roughly the equivalent of the guardian ad litem in this system alone. The guardian ad litem light, to say the least. But think about having somebody from the child advocate program present at the court. Think about having the LOPC program, which is the orientation program for children's custodians at the court, so that you almost have a one-stop shop where kids can at least, again, be reinforced with information to know you need this help to get through this system. I'm not saying that we do a kind of, if you will, an attorney for the day program where the attorney provides counsel that day. I think it's got to be the beginning of the process and not the end, but something to think about. A regional approach. Based on conversations I've had with government agencies in Washington, I am concerned that the focus may be on how do we stop this flow rather than how do we understand this flow and what is an appropriate response at that point. And this is not just the role of the United States, this is the role of sending countries and transit countries as well. So I think a regional dialogue would be very helpful. For kids who either decide to go home or who are ordered deported, we need a better focus on the return and reintegration of those children. This idea of the system just being kind of artificially carved out in the United States, and once a child's gone, it's not my problem. I think, has got to end. We need to really look at what happens to kids once they go home. We're piloting a project in Guatemala right now, partnering with 4 Guatemalan local NGOs, so the kids are welcomed at the airport, the family is there with the NGO, that they're provided transportation back to the home community, and then based on an assessment that we do here in the United States, services kick in, and that may be enrolling the child back at school, that may be supporting the family to make sure that reunification is really solid, it may be ensuring that the child has access to whatever health care they need. But those kind of initiatives, I think, are very important and should be supported. And then finally, I'm going to end where the point Don made. Still in the immigration system, there is an absence of an adequate consideration of the best interests of the child. I would argue that we still have a system that primarily looks at these kids as immigrants first and children second. And as you said, we need to flip that around. And we need to really think through what's in the best interest of each individual child. And we need to also ensure that that child's voice is heard in the process. New York has been a leading community on this issue really from the get-go. And Judge Videla and others at the court have done an incredible job trying to make the adjudication process as child-friendly as possible. We need to bring all of this together, again, look at this influx as not only a challenge but an opportunity, and really start to plug some of the holes in the system that still exist.
Judge, yeah.
Thank you.
This is Wendy, who's just joined us, so thank you for coming. It's okay.
Thank you, Don, and thank you, Wendy, and thanks to CMS for having invited me to this program. The first thing I have to do right up front is I have to give a disclaimer, because technically I work for the Department of Justice, and I have to clarify that the views that I express here today are my own personal views. They don't represent the Department of Justice or the Immigration Court or anybody but myself. But let me first give you a little historical background about the juvenile dockets here in New York. We have, at the present time, 3 individual judges handling the dockets. Once a month, we have each one of the 3 judges has a non-detained docket. And then there's an additional docket, is the detained docket that I also handle, that is going to be, I understand, is being considered for expansion because we have a new facility in Lincolndale, New York. It's called Lincoln Hall, and detained respondents are going to be housed there. So obviously there's a need for an additional docket that is in the process of being formulated and announced officially, I believe, very shortly. So that is consistent with the perception that the numbers have increased. I also want to add that in the last couple of months, and I've been doing this for about 8-9 years, I definitely noticed that the average age of respondents has dropped dramatically. That's just anecdotal at this point, but it is consistent with what you're perceiving. I was told that maybe we're seeing more respondents who are younger simply because before those respondents never got to New York, and now because of the way they're being housed in different parts of the country, they are making it to New York because we are expanding. But I'm not sure what the cause is, but it's definitely something that we need to look at, because I think that younger respondents have different needs. And obviously also different vulnerability, they're vulnerable to different factors that we need to look at. Now, that goes to one of my first strong views that I have in these cases, and that is that in an ideal world, I believe that every respondent who is a minor under the age of 18 should appear in court only with a legal guardian. And I'm talking about a guardian appointed through the state process. Now, it could be, what has already been done in a juvenile petition, but that may come later. Why do I say that? The fact that they have legal representation is good, it definitely is. But I found that once you match the children to legal representation, the appearance rate goes way up. Very few of those cases do not appear once they have legal representation. So I am grateful for the work that KIND and other organizations are doing, because I feel more confident that children are going to continue to appear. and therefore I'm going to be less concerned about some safety issues. But in my view, the fact that somebody is represented but they're legally incompetent. Now let's remember back to some of us who are lawyers, went to law school, right? Certain people are considered by society to be legally incompetent, meaning that they cannot speak for themselves. A person under 18 is one of them. For example, as a society, we make a judgment that you cannot enter into a legal binding contract with a minor. Right? They could be 17 and they'll go and buy a car or whatever, they walk away with the car where the dealer loses because that contract is unenforceable. That means that society we make a judgment that that individual is not mature enough to make decisions like that. And that's only what? That only involves money, right? It's not really such a critical factor involved. Here we have a child who appears before a judge and has to make some critical decisions as to how the case is going to go. Some kids, for example, after being detained for a while and then are able to locate a potential sponsor to release the child to, they may just become frustrated and say, I want voluntary departure. I just want to leave and go back to my country. And that may not be the best situation, especially the things we just described about the conditions of Guatemala, the described sale and all that. And therefore, how could you expect a child to make a decision like that? Now, the fact they have a lawyer, that doesn't resolve the situation, because that lawyer is not acting in the capacity of legal guardian. And we have, I see a situation that is difficult to explain from a legal point of view, that you have a lawyer representing somebody who is legally incompetent. But that doesn't make the principal here, the child, competent, does it? Unless that lawyer is also the legal guardian. And to get to that, you got to go through the state process. So you probably heard me advocate for this before. I think that in an ideal world, that would be the best situation. In every case, immediately get the state involved and appoint a legal guardian. I know there are financial considerations to that, there may be limited resources and all that, but I think there's a lot at stake here. And I don't think that there's that many cases that any state is going to be particularly bankrupt because they have to go through this process. But again, that's my own personal view. Now, another issue that greatly concerns me is that ORR, the Office of Refugee Resettlement, I think is doing a great job with the resources it has to screen potential sponsors. Briefly, the procedure involves doing a home study. Every person who is part of the household is fingerprinted, they do background checks to make sure that there are no exposure to the child, and so on. But there are some flaws in that system, and one that concerns me is that there is no follow-up once the child is released. In fact, looking at their own operating regulations, they specifically say once the child is released, they don't have any other follow-up duties. And that's a big gap for two reasons. Number one, there is no evaluation of your screening criteria. Right? For example, if you see too many cases where the child is released to, let's say, a family friend, and then among that group of respondents, a very high percentage never show up in court, then you know that there's a problem with that screening. And you need to go back and see it. So there's no follow-up in that sense to kind of like sharpen the criteria that you use for these cases. Number two, and this I mentioned a little while ago, there is no follow-up when the child doesn't appear. And I get a small percentage of those cases where the child simply doesn't appear in court. Neither does the child or the sponsor. Now, I myself personally, what I would do, these cases are heard in the morning, so in the afternoon we address the no-shows, and I will actually get on the phone and in the presence of the trial attorney. The trial attorney is the government attorney who represents DHS in removal proceedings. I will call the sponsor, and many times, as many are from Central America and happen to be bilingual, I will address them in Spanish, and they're shocked that the judge is calling the sponsor. Well, many times the phone is disconnected, and that's the end of the matter. There's nothing else I could do. The government persuades me or tries to persuade me to issue an order of deportation in absentia, and that they will then go ahead and do different things. But I tried that years ago and no results. Now, I've never seen a case where they've actually gone in and found anybody or tried to. Maybe they do, but they're not. I'm not seeing any results. And I'm very concerned. You know, New York is a very large city, and to have a child out there, you don't know where the child is or where the child went to. You know, potentially there could be, you know, some serious consequences here. And I'm concerned. Nobody is addressing that issue. I tried different things to administratively close proceedings with the problems that they'll look up the child, adjourn it several times, and nothing happens. Now, when I do get hold of the sponsor, when they do answer the phone, I found that the biggest thing that I can offer them, the carrot, so to speak, is if you come to a master calendar hearing date for the juvenile docket, you will have access to the competent counsel, you know, pro bono, and that might do it. You know, that might do it. And they will come back to court, and once they make that connection, then again, the appearance rate shows up. But that is a concern that we have. Another one, it's an ongoing one, and it has to do with, I guess, the regulations not covering this either. What happens if the sponsor simply walks away from his or her obligations? To review briefly what happens when ORR determines that this sponsor is appropriate and the child is released to that person, that sponsor will agree as a condition of the release to do certain things, to come to court with the child, to make sure the child goes to school. I mean, there's a whole checklist of things they have to do. What happens when the sponsor simply stops coming to court? They are not covered anymore. Now the child is with somebody else that we don't know about. There is no procedure for something to be done. Now, technically, DHS could decide to take the child back into custody, put him back to ORR, and then make another determination of the new sponsor. But even that I haven't really seen happen. So we have a gap about that. Now, the other issue that I want to address is that with respect to the detained respondents, we have a unique arrangement in the juvenile dockets when we handle detained respondents. And that is that we allow pro bono counsel to appear as a friend of the court. That is, formally they will not file a notice of appearance, so they will not obligate themselves to do anything rather than some initial screening. But they are very helpful to us because they immediately determine if there is some application for relief. In the immigration court, that means, is there a way they can apply for something so that the case can be resolved favorably to the respondent? And for example, the most common form of relief is usually the special immigrant juvenile petition, which requires somebody going into family court, filing a petition, and having the guardian appointed, and then they file an application. It's called an I-360, which is sort of like the visa petition, and then once that's approved, the case goes back to USCIS to do the adjustment process. I don't want to, bore you with the details, but ultimately the person gets status in the United States. Now, this process is not really that complex. I don't know if the providers that normally appear before the court would agree, but it's not something that in substance is so complicated legally that you need to go out and do a lot of legal research and you have to use a lot of resources. I think that what it is that you have to, number one, know how to do it, what steps to follow. This is why I also appreciate the pro bono counsel, because many times when I have a private attorney appearing for a respondent who is helpful but doesn't really know, I try to schedule that case at the same time as I do the other juvenile docket where we have the pro bono counsel, to talk to the pro bono counsel. The pro bono counsel have been very helpful, trying to give them some tips and trying to lead them into doing the right things. And that's brings me to the issue, I think Wendy, you were mentioning it too. The numbers are increasing, so the need for pro bono representation is going to also increase dramatically. Right now, unfortunately, we have quite a gap between the time that we have a respondent screened by one of the organizations and the time that we get somebody to come to court for them. I think right now it may be taking it after about a year, and make it even longer. And I'm worried because during that year, the child may have to appear 2 or 3 times before the court. And as I said earlier, once you have legal representation, the chances that the child will continue to appear are very great. So I'd rather have that matchup between respondent and pro bono counsel to happen as quickly or as early in the process as possible. And that's an area where we always need more help on. The court has been helpful in trying to participate in training for pro bono counsel, and that has been also effective in trying to get new people involved. But wherever it is, we can always use more help. I just want to add a few comments to what Wendy said, where the cases are coming from. I think that by far the largest percentage of cases come from people who were intercepted either coming in or shortly after they came into the United States through the U.S.-Mexico border. But those are not the only ones. We also have individuals, juveniles, who got involved somehow in the criminal court system, and DHS put a detainer in them. When they determined that they were juveniles, then they would be turned over to ORR. Those cases present some particular challenges because depending on what convictions took place, the person may or may not be eligible for some relief. But those are just a small percentage of the cases. We also have just individuals who have been around, minors who have been around for a while in the United States, but they were encountered in some transportation route. It used to be that the Greyhound bus and Amtrak were places where DHS would stop and pick people up, and that's how they would be placed in proceedings. Now, there are also other applications for relief in addition to special immigrant juvenile status. I've seen some success with U visas, which also bring relief to people who have either been trafficked or been the victims of trafficking. And one of the bigger ones, I think, after special immigrant juvenile petitions is asylum. Asylum, however, does present additional challenges because it does require a little more legwork, particularly if the attorney doesn't have a lot of experience doing that type of case. Special rules have applied to asylum cases, and particularly to juveniles. Some children, but a very small percentage, and it may be my impression only, but I see even less and less is voluntary departure, where somebody just says, I'm leaving and going back. Even in the detained docket, where I would have probably some of those cases, even there I see very few. Maybe out of a typical master calendar hearing, which will include about maybe 30 cases, maybe there'll be one, maybe two, but very few. So that means that the other 29, 28 need representation because they're going to need to do something else that's beyond, it's just beyond being in the immigration court. Another relief that we've had in the last year or so, that's prosecutorial discretion, and that is that you ask the government to exercise prosecutorial discretion not to proceed with the removal case, administratively close it. And there's been limited success on that. I was hopeful in the beginning that it would result in more cases being administratively closed, but it for some reason it has not panned out. I don't know what the others have experienced in that, but is it? Now, a couple more items. What goes on in the immigration court once the child is released and appears before the non-detained docket. There are certain procedures that we follow that are unique to juveniles, that we don't do it with the adult respondents. For example, the judge will not wear a robe. We try to make the environment as less hostile as possible. We also do receive some special training to handle juveniles. Sometimes I've been criticized for pushing that a little too, they're not doing well in school. But actually, it's great if they're doing well in school. I don't think there's any prejudice to anybody, especially the kid, if they're doing well in school and getting an education. But I'm also concerned because when the child is going to school, and I look at the report cards and see that they're absent only a few times, I'm more confident that if there is some abuse or neglect, the school authorities who are trained to detect that will take action. But if the kid's not going to school, I immediately worry. And I talk to the sponsor, they empty out the courtroom to speak directly to the kid without having anybody else present to see if there's an issue. Why is the child not going to school? I ask if the child is working or not. This is when we identify that we don't have necessarily, so ORR, again, may need to look at their criteria again for screening and see what goes on. Now, that is actually what we do in immigration court, and other than again to say that the numbers have temporarily increased and that we need more help in terms of legal repression, and for action to be taken in a higher level. See, the problem I see here is that many times there may be parents here, but they have no status. So they have a dilemma here. Do they come forward at the risk that they themselves will end up, or they just send a stroller to act as a family friend to become the sponsor, but then really has no interest in the child, so the child doesn't appear in court or whatever. We have no, know that the child is with the parent, then again, I feel confident that child will probably have the same situation as any other child with respect to any potential abuse or neglect. But the problem is when we don't know where the child is or who. I noticed, for example, in the past, if I call the sponsor, actually, the kid went to North Carolina quite a few years, and sometimes I criticize for pushing that a little too hard, and some kids not feeling good when they're not doing well in school. But actually, it's great if they're doing well in school. I don't think there's any prejudice to anybody, especially the kid, if they're doing well in school, getting an education. But I'm also concerned because when the child is going to school, and I look at the report cards and see that they're absent only a few times, I'm more confident that if there is some abuse or neglect, the school authorities who are trained to detect that will take action. But if the kid's not going to school, I immediately worry. And I talk to the sponsor, they empty out the courtroom to speak directly to the kid without having anybody else present to see if there's an issue. Why is the child not going to school? I ask if the child is working or not. And again, this is when we identify that we don't have necessarily the best sponsors. So ORR may need to look at their criteria again for screening and see what. Now, that is essentially what we do in immigration court, and other than again to say that the numbers have temporarily increased, that we need more help in terms of legal representation, and for action to be taken in a higher level. See, the problem I see here is that many times there may be parents here, but they have no status. So they have a dilemma here. Do they come forward at the risk that they themselves will end up in proceedings, or they just send a straw person to act as a family friend to become the sponsor? But then what happens? That sponsor really has no interest in the child, so the child doesn't appear in court or whatever. We have no idea what the child is. Now, if I know that the child is with the parent, then again, I feel confident that child will probably have the same situation as any other child with respect to any potential abuse or neglect. But the problem is when we don't know where the child is or who is the child with. I noticed, for example, in the past, if I call the sponsor and they tell me, well, actually, the kid went to North Carolina with his mother. Well, that's fine. I say, let the mother let us know. We'll change the address. We have an immigration court in North Carolina. Let the parent come forward. That would also be something to consider. If there could be a consensus with DHS to say, look, because we have so much at risk and we prefer to protect the child and have that parent come forward, can some arrangement be made where that parent will not be put in proceedings just for the sake of having the parent come forward? And I know that for policy reasons, they may say, well, that's not a good idea because we're giving a free pass to somebody who's out of status and so on. And that's valid consideration that they have to look at. But again, I think that we need to make a decision here. What's the better situation of two situations that neither one are perfect?
Yeah. And there was precedent, if you remember, in IRCA, big legalization program in 1986, information is protected. protected.
Right.
So that the person, if they came forward and applied, didn't qualify, they wouldn't have been.
To encourage them to come forward
Right.
and to say that. I think if we had, again, we're not talking about that many people in comparison to
Exactly.
the population of people who are out of status in general.
Right. That was a much bigger program
Exactly.
than the
And considering what's at risk here, you know, I'm not sure that, you know, it's not a bad decision to make to give these people a break just for the sake of protecting kids.
I think it's really good. Judge, we probably should move on. Thank you very much. Appreciate it. And we'll get into some of these policy issues in the question and answer. Thanks. Wendy, thank you for joining us.
My name is Wendy Claudio, and I'm the director of the Children's Village Shark Program, and we have 4 shelters and 1 staff secure. Our shelters are the least restrictive environment for the children that come in, and our staff secure for children that have behavior issues, flight risk, and some criminal background. And we provide them with case management, clinical services. We work in coordination with the program attorney, which is Catholic Charities. And we have an educational program within the school. And our main focus of the program is case management and clinical services. It's a team collaboration. And the case managers are the one who works with the children to find the sponsors in the community, to speak to the parents and get all the paperwork for the reunification package. One of the things we do is interview the sponsors, and because we're in New York City, in Westchester County, and have access to subways and trains, we have able to do visits within the facility and establish relationship with those family friends or those aunts and uncles that they haven't seen, even parents, because some of the parents have left these kids when they were about 4 or 5 years old, and these kids are 16, 17 years old, so they don't have a relationship with the parents. They may have phone calls, but they don't have a relationship, and we're able to engage with them. We try to be out of the box. We try to have family therapy sessions over the phone and try to get some of the issues out there. Abandonment issues big, trafficking concerns. A lot of these kids were involved with gang or were exploited by gangs. So we try to work with them. We do have a lot of external services. We have psychiatric services, neurological. We have specialty. We work in coordination with Westchester Medical Center with OBGYN because we do have girls that come in pregnant. And we have girls that come in with their babies, and we provide them with parenting courses. We try to work with them so when they're out in the community that they can work with the sponsor, but also be independent, because we know that the sponsor is taking on a big responsibility for taking care of the kids. And we try to ensure that they go to school and that they do proceed with the legal court hearings. One of the things that we do work with, I'm also the director of the PostRelease and home study program. We go into the home and we assess the homes when there's concerns. And after the home study is approved, we do provide post-release services for 6 months. If it's a post-release discharge, if it's a home study post-release, until the child reaches 18 years old. And we try to involve them in mental health services, involve them in the school, after-school activities. We work on basic parenting skills with the parent, the sponsor, and the child, because a lot of these sponsors are family friends, aunts and uncles, family members they haven't seen in a long time, so we know that they don't have a relationship. So engaging them, because these kids have been working out in the community, working in their home country, that they're more of adults. So how to get the parent-child relationship, because in the home they're going to be a parent-child. So we try to work with them in that, in the post-release services. But our big program is case management and how to ensure that these children are with the right sponsor, and interviewing them, assessing them, constantly having phone conversations, following our policy and procedures, making sure that they're having their phone contacts with them, and then interviewing the sponsors, interviewing the kids on a weekly basis or on an as-needed basis to make sure that the kids are having conversations with the sponsors, what the conversation is like. Do they have any concerns? Expressing to them the importance of going to school, following through with immigration court's hearing, especially when you go to immigration court, have your report card there, because the judge wants to see that. We also speak to the sponsor that it's important that the kids go to school and that they need to go to immigration court hearing, and they need to ensure that the kids go, because we don't want the kids to be put out for warrant of arrest with children. And we try to help the sponsors understand the importance of that. Whether they follow through or not once the child is discharged, unfortunately, we don't know, because we have limited access once the child is discharged. But we do work with the kids in the community in post-release services. In the case management, we also provide them with a contract, a safety plan, if we have some concerns that they're not eligible for any kind of services when they get out of the community. and we find services in the community for them. We find mental health services, we find a school program. We actually help the parents enroll the child and have the paperwork ready before the child is discharged to the school, discharged to the sponsor. We also ensure that they're getting medical services, because a lot of these kids come in sick, diet needs, so many different sicknesses that these shouldn't come in, and we want to make sure that we start the services, we start getting the medical services for them, that they continue once they go out into the community. I mean, I guess my thing is, if you have the questions, I will answer them, because it's a great program and we work really well together. And I mean, we try to do the best for the kids when we can, that with enough can.
Have you seen a kind of an increase in the number of kids in receiving your services? And what percentage are case management versus kind of shelter?
All the children receive case management services.
Right.
We have
Case management meaning, released in terms of their case being managed. Post-release
services. I would say in our particular program, about 45% get post-release services.
Okay. And then the rest are in the
Are released without, but we try to put in a safety contract with them when they leave.
Okay. So, well, thank you. So it seems to me like we're going to open this up for questions, but I'm going to ask one big question to everybody, which is that it seems like there's still some vulnerabilities in this system, and some concerns that the judge expressed, whether about screening kind of potential sponsors and guardians for these kids, which is complicated by the fact that some of these folks might be fronts, I guess, or people that are proxies for parents that are out there. And the second being kind of lack of follow-up on reintegration of kids, which is surprising to me. I remember there used to be programs for repatriated, or actually repatriated, deported people to Salvador and to the DR and to other places, but I never heard about them for kids. So that's interesting that there's one in Guatemala, but not elsewhere, and nor does our State Department ever follow up on kind of how they're doing in any cases. I mean, it seems like a fairly glaring thing. And then I wonder too if there's safety concerns not related to kids without counsel, but related to kids with counsel. And I remember back when we ran a project for unaccompanied Chinese children, and we were shocked. We were entering appearances in those cases, and we're shocked to find out that there was the same attorney that had already entered appearances for several hundred of these kids, and how that attorney possibly knew who these kids were was amazing to us, because they had all come over, they'd all been smuggled over, and it was quite clear that this guy was working for the smugglers. And so I wonder if there's a vulnerability there as well. And then we'll open it up for questions.
With respect to the Chinese respondents, absolutely. I have one case right now that's pending that is represented by one of those attorneys, and I think that raised, my concern was that I looked at the report cards. It was a 17-year-old female, and she essentially went to, I don't know, maybe 5 times she went to school in the last 3 or 4 months. So.
And what do you do, and what can you do in a situation like that?
That's the problem. That's the problem. I mean, in that case, I think, it may sound harsh, but I know what the facility looks like. I toured it. I also toured Children's Village in Queens. And I feel that the child will be safer there, right, until we figure out what to do with the child. Mm-hmm. Now, I do want to mention that sometimes there is no sponsor identified, and the child may end up in foster care, either in New York or outside New York. Mm-hmm. It's another alternative. That's something. But that's a concern, and I think you hit the nail on the head, particularly with that nationality. That's a great concern, and I know exactly what you're saying. That lawyer who's appearing in that case is appearing in countless other adult cases where we know the smugglers are involved.
Right.
So clearly, this individual cannot have the best interest of that child. Absolutely. They're serving somebody else. That child never retained that lawyer in the traditional sense.
Yeah. Okay. Any questions, comments? Yes. Joe.
Just related to what.
And if you could identify yourself too.
Very Joe told Sisters of Notre Dame, and I work as an advocate at the children. And tagging on with what you asked, Don, I know that when we were working with trafficked people, in addition to someone who repeatedly appeared in court, people would appear who were an uncle or friend of the family. And given the fact that many of these children have not been with their family or friends for a long time, what is done to distinguish so that someone doesn't come forward posing as a family friend or trying to be a sponsor? Is there? And the other comment I just wanted to make about the situation in El Salvador, at the UN when I first came about 5 years ago, they were already concerned about the gangs in El Salvador, which were being formed by kids who had been deported from the United States. So the program of follow-up is really important. But I'm mainly interested in how you would determine, because these would be various different people who are posing as family friends or an uncle.
Yeah.
Thank you.
Well, and Wendy and Judge Videla may have more to shed light on than I do, but I can tell you that in terms of releases to parents, as ORR is looking at this in turn, again, to free up bed space to accommodate new kids coming in, one of the things that they're looking at is for parents simply a fingerprinting process, and then really nothing beyond that. And you know, we're in a bit of an awkward situation, if you don't mind me saying, in that you know, we have for many years advocated that children should be detained for the shortest period of time possible. But right now I'm feeling a little bit like we're in a be careful what you ask for situation, because it's one thing to release children quickly when you've got adequate checks in the system to ensure that the releases are appropriate. It's another thing to be doing it this quickly simply for reasons of opening up bed space for others. So I think there's a lot is developing very quickly on this issue because the numbers spike so quickly, and I think that our opportunity time is now to get in there and start advocating. Let's make sure as we change the system that it's really grounded in the child's well-being.
The process of the sponsorship, what we do is we ask the parent to write a letter of designating where they're stating that they're going to allow this person to provide a guardianship, and they're going to have to establish what the relationship is, whether it's a family friend, of the relative or neighbor who agrees to it, and we interview the family member, and if they're close enough, we ask them to come over and come to do visits with the child and start the relationship in the facility. We start with doing supervised phone calls also. I mean, we can't, the little time that we do have, we try to make it work together.
But do you have some, to answer the question that was raised earlier, do you have some kind of an agreement or protocol with, you know, DHS not to, if the parent's unauthorized, that they won't care to know that, or that they won't kind of enforce the law against them? When you reach out and you find out an unauthorized parent, there must be some kind of agreement, or they're just not part of the loop, maybe.
Well, with this unauthorized parents, we always try to get to the parents first, because the parents have to sign a letter stating that they're agreeing to this person to sponsor the child. And we also have weekly phone calls with our federal appeals specialist, the representative ORR, and they're constantly in the loop, and they actually get the package and they review it too. And we also do CANS check, a background check, fingerprinting on them too. We ask for their verification of income so we can make sure at least they can financially support the child.
These are cases when the parent isn't assuming guardianship.
Isn't assuming guardianship.
Is or isn't?
Isn't.
Isn't. And if they are, is there any kind of, do you have any kind of agreement or protocol with DHS about those cases?
We have to ensure the relationship. We do get birth certificates and everything to ensure that there is some kind of relationship, and we do go through the same process. We don't, just because they're the parents, we don't make this process smaller. They do have to provide us the same paperwork and go through the same checkpoints that the other sponsors do too.
I think, Tom, what you're asking is, do you have an agreement that you won't put the parent in custody? Well, at the 26 federal plaza, which is where our immigration court is, whenever I hear on the respondent or somebody, the parent is afraid, is around and actually maybe living with the child, but is afraid to come in, I tell them, come in, bring the parent in. They would never, no, there's no understanding, there is no protocol, no agreement, but they've never put anybody into custody or done anything. So, I mean, there is de facto something that's been working without any assurances, And some of the parents will take you up and will appear. And that, I tell you, that will decrease the level of concern and tension. Now I know the kid is with the parent, and
Can I actually just call on Kat, who's on my staff here in New York?
Sure.
She just joined us from Bar, which is affiliate of the American Bar Association that's working with the kids at the border. Kat, would you, I mean, what's going on at the border in terms of the facilities down there and when kids are released? Because my understanding is a lot of the parents won't come forward because of the very extensive checks that go on along the southern border, and they're afraid to kind of run that gauntlet to come and accept custody of the child.
There definitely is a fear within, the undocumented immigrant community, as I can tell within the United States, in terms of coming forward, because they're, even though working really well in New York post-release, a lot of parents don't know that before they come forward, and ORR doesn't have, to my understanding, doesn't have an exact policy with DHS regarding undocumented parents. And we have seen situations where I did when I was at Pro Bar involving parents with removal orders who came forward to sponsor their children and were picked up by DHS in the process of doing that. So that is a danger that's not really being discussed, to my knowledge.
Somebody had a question or a comment here?
Hi, my name is Lillian and I'm a law student at Columbia, and I've been interning at the Legal Aid Society working with Kathleen Maloney. My question is, how many of the kids or the young people are released percentage-wise to parents, even if they are undocumented? Do you even have numbers versus just actually guardians or friends of family?
Offhand, I wouldn't know the numbers, but I know there was a high release of parents.
Even when they are undocumented?
They're undocumented.
Okay.
We do ask the parents to step forward and
Right.
sponsor their children, but we do let them know that we're not immigration, and they do feel safe in our facility and come to visit the child.
Thank you.
Karen?
Thanks, Rachel. I had one short comment and then a couple of questions. One is on this unrelated adult or suspicious adults coming in to court with the kids. I recently did a training program for the ABA for pro bono lawyers to represent kids together with Kind, and there was an immigration judge there from Charlotte who has the children's docket. And she related a sort of an ongoing problem with this unrelated adult issue coming in. And she was describing a day where she confronted this one, as she called, strange man that was in with a young girl who didn't look like he would fit the profile of a relative or family friend. So she questioned the young lady to no avail, and then asked the gentleman outright, who are you? What's your relationship to the kid? And he got up and said, I'll be right back or something. I have to make a phone call. He never came back. And she continued the case, and the kid never came back either for the continued date. So she was expressing a concern with the tension between confronting the problem when you see it and losing touch with the child altogether when you do surface the problem. So I don't have a solution for it, but I wanted to just mention that observation.
And Judge Videla, I'd love to hear your perspective on this. What I've seen as I've sat in on the juvenile dockets in various places is the judge is often stepping up and trying to fill a void in the system, asking questions of the child, are you enrolled in school? How's it going at home?
All the time. But
Yeah.
in that particular case where there's a concern, what I would do immediately is ask the sponsor to leave the room so that we can speak to the child directly and see if the child now feels more comfortable. And also emptying out the whole courtroom. There will be nobody else. And we have the interpreter and try to see if there's a problem. Will the child say anything else? Have any concerns, any fears? And we think that without the sponsor being there, then maybe they have a chance to get someplace. But we don't know. It's a concern, and I'm always grateful to anybody in the courtroom who may notice some unusual activity. Sometimes it's my clerk, sometimes it's the interpreter, sometimes it's the government attorney. Because they're on the other side, they heard maybe something that the sponsor said to the child or whatever, and that's how we pick up on it. We have to be very sensitive to these things. We have to be very alert. But as reset the system is less than perfect. But I want to clarify something. I don't want to sound like it's all negative, all criticism, because I'm very grateful that we've come a long way. You know, years before this was in place, I mean, it was really bad. So now at least we have something in place. So I don't want to sound like, you know, we should do away with it. Not at all. You know, we got to work on it, but it's not, you know, it's not that bad.
Yeah, and you know, I actually think this is an issue that's solvable too. I mean, we've demonstrated that over the years. You take a step forward here, you take another one over here, then this problem comes up and you fix that. I mean, that kind of momentum we need to just keep sustaining. And you're right, glass half full, not half empty.
And then here are my two questions. One, Judge Videla, you alluded to the training for the immigration judges specifically with regard to conducting proceedings for children, and I wanted to ask you your perception of that generally, and in particular for judges who are going to have a children's docket, whether you think that's adequate under the current system. And the other one is addressing your point about the need for somebody in a quasi-GAL capacity, somebody representing the best interests of the child in immigration court. For you and for Wendy in particular, I wanted to ask about a model like what exists in family court when there's an abuse and neglect case or a custody case, that even if the parties are represented, including the children, judges often appoint lawyers to serve as GALs to do an independent assessment of best interests and submit a report to the court. And I wondered if there's been any consideration of that model of using lawyers not as advocates for the kids, but to serve that report on the best interests assessment to the immigration judges, even short of obtaining a legal guardianship or an order in the family court.
Right. Well, I'm not sure how it would be the best way to initiate that process. I was always under the impression that in any state, any adult becomes aware of a child being essentially neglected or abused, you make a report, and then the state immediately gets involved, depending on, you know, what's at stake. But eventually, if it's determined that nobody in care of the child and so on, I mean, clearly something needs to be done in terms of guardianship, or somebody who's going to have to make a decision for the child at the beginning on a temporary basis, but then more permanently. I mean, I think most states have something in place. That's why I thought, you know, let's not reinvent the wheel, because it may be more difficult to do so. Let's adopt this that's already in place and allocate resources to that if they need additional resources. So that's, you know, again, I would say that would be very, very helpful, but I'm not sure exactly how it should be done. That's something that needs to be discussed and see what's the most efficient way to do it.
Long before the Trafficking Victims Protection Reauthorization Act passed in 2008, there was legislation introduced in the late 90s by Senator Feinstein and Zolofkin in the House called the Unaccompanied Alien Child Protection Act, which then morphed into what became TVPRA. Originally, there was a provision in there establishing a guardian ad litem role for kids in immigration proceedings. And as the bill went through the process, it was stripped. That provision was stripped and replaced with something that created the Child Advocate Program, which is a very kind of watered down version of a guardian ad litem. They're not appointed by the court, and they have no reporting requirement to the court. It's currently administered at the University of Chicago by the Young Center for Immigrant Children. Horribly under-resourced. They're only provided $370,000 a year through Bureau to function. So they've been largely limited to assigning child advocates either in Chicago, or they just recently opened a program in Harlingen, Texas. And then they will stretch to try and help particularly vulnerable cases as they pop up in other places around the country. But I think it's something that it's a start, and it's something that we should look at and see if we can make it a more robust program, and that we can provide criteria through which children who require the guardian ad litem are appointed a guardian ad litem. Because right now it's very murky, to be honest. So we tried, I guess.
What was the first question?
About training.
Oh, the training, right. That's a good question. In fact, as I said at the beginning, we're in the process of adding another docket. So what we're going to do is we're going to do one-on-one with that judge. The judge will observe us, and then we'll have individual sessions. In that aspect, I think it's very comprehensive. Now, we also, to all the judges in jail, right now, I said earlier that we have the week of training. We have at least one session that has to do with children, particularly for courts where they don't have a separate juvenile docket, so the judges are aware of these issues. There's an explanation what ORR does, that they use the criteria to release to the sponsor, and all of that. It's all explained to the judges, So it's working, I think, well so far. I mean, we are allocating, I think, adequate resources for training of those judges. Yes.
I have a question. You mentioned that like a juvenile docket, and I was wondering whether sort of voluntary departure should be maybe eliminated, or maybe like in terms of for children, unless there is really somebody who does a study and there's an independent person who really investigates the conditions in the country of origin. I thought that was the biggest nightmare in terms of like not doing what's in the best interest of the child, and it's the institutional pressure.
Can I add something to that too? Is there any coordination at all with any of these governments on kind of return of these folks? I mean, we know that we're not monitoring it.
There is, but very limited. The child will be escorted, and there will be somebody in the receiving end. All these arrangements, I mean, I'm hearing this secondhand because I'm always asking, when is the child going to be traveling? Because once the child decides on voluntary departure, the big question is, well, I don't want to be here indefinitely. And they tell me it takes them about 10 days after I issue the order, 10 days after they get the documents from the consulate involved. Let's say somebody from Brazil have a document, and within 10 days they're able to do that. There is a nice juvenile coordinator who will follow up on that, and they're supposed to have someone at the receiving end. Now, I've seen different reports that I think El Salvador may have this, where they don't do anything special, but they do have someone at the other end receiving them, and supposedly they're reuniting them with family. Now, how much inquiry goes into that, I don't know.
What you may be talking about, can I just interject there, is under TVPRA, State Department was mandated to pilot a return of the integration program for kids that was took place in El Salvador. It's about an 18-month
That's
project.
the one I heard about.
Yeah, and it was.
Is there a report on it?
There is a very short report that came out on it. It's not, frankly, very enlightening. And it focused primarily on kids who had been trafficked and were returned. And my understanding is basically the idea was that they would be welcomed at the airport and then returned to their families in some family.
I share your concerns about voluntary departure. I directly addressed the child and I asked them, do you have any fear of returning? And, anything. And if they say yes or whatever, then I will not accept voluntary departure. But I know we had one case, was it Ms. Cushion, the one that changed his mind 3 times? I granted him voluntary departure.
Not many, but we've had a few cases where kids do change their minds. And we've asked the court to reopen the cases.
And we do. I mean, we understand it's a big decision, and they may not be in the best frame of mind when they made it. But I know one case, there was at least 3 times I reopened because he changed his mind. And I understand, I mean, people get frustrated, but let's remember, they're children. Sometimes I try to put a human perspective on it and figure out, let's see, some of my nephews that I have and nieces at that age, and I try to put them in that place, try to make a decision like that, and I go, wow, no way they're going to be able to make a good decision. So why should I put more expectations on somebody who may have less formal education, less of a network and all that? And that's the thing. I mean, some of these cases, I tell you, as a judge, they're tough. I mean, they get to you. They do. Especially the little ones. And when you see that there's nobody there looking after them, it's very, very frustrating. And I've had situations where I've had to get very strong with the government attorneys saying, what are you guys doing? But again, I'm not sure, what power they have. So we have the bully there. That's the problem.
I think something that I think should, as a comment, should also be mentioned is the fact that a lot of kids go into adult detention when they turn 18, and that's one of the huge stressors in this whole system, because if they are too old to go into foster care, and they have no sponsor, it's likely that these kids are the most vulnerable. And then there's nobody that's going to get them out from detention when they turn 18. So one of the reasons why they may decide as a strategy that they would rather voluntary departure than go into adult detention. So this is a huge dilemma for them. It's a huge dilemma as an attorney to be able to advise your client as to, what to do, or, what the process is like then when they do go into adult detention. And the challenge to present a case to a judge of an 18-year-old who can't pay a bond, even if it's $1,500, who has nobody there, and the arguments they usually make for an adult in terms of why this person should be allowed to come out of the detention facility are really no use when you're dealing with a minor who's been abused, abandoned, or neglected, who has no family and no support system. So those are one of the greatest challenges, and that's also linked to why some of the kids may decide to take voluntary departure or may choose to do so.
Well, I was really impressed. I don't know if I told the story to some of the people here before or not, but one time I had pro bono counsel during this case, and there was a motion to withdraw. And I said, oh God, why? Because now we're going to lose another representative. And then I looked at the motion, and I ended up granting it very happily, and it was because the lawyer had decided to become the guardian. The sponsor wasn't doing the job, and the lawyer decided to, yes, just go to family court and take up that role. They developed a relationship over the time they were representing her, and I thought, wow, that was very touching, and it brings a human element into this whole process. That's ultimately what we want to do, help the child out. You know how many times I talked to the other judges who do the juvenile docket that we wish we could do that. I would have 10 kids already. It's very compelling. I mean, really, their stories, are very moving, and you want to help it out. And of course, we can't do that.
Go ahead.
Sorry.
Darin Salgado from the Mexican Consulate. I have a question. When you were talking about voluntary departure, I deal with minors. That's the area that I have. And most times when I do voluntary repatriation, I do whatever it takes to make contact from here with the family. I ensure that the minor is taken to the airline, that somebody takes care in the airline from him, and we notify Mexico, and somebody picks that person up in Mexico. Besides, from a family member, I make a phone call and I ensure that the kid is safe at home with whomever they are going to take care of him. So what is the collaboration that you have considered to making that through the consulate? Because we are the ones that are going to be able to locate the family back in Mexico or locate the family here, and we actually make a big effort to do that. So the kids are not alone. They should have a parent somewhere, if it's here or if it's back in Mexico. So perhaps we would be very happy to engage in further collaboration.
What's the collaboration now? How do you connect to the kids?
It's not really that good. We don't really get notification as much. Yeah, maybe my colleague, she has been there for a little bit.
Okay.
No, I mean, there is a lot to be done. I agree with Eddie. We actually want to engage more. Most of the time that we come into action is through Children's Village. They're the ones who take the kids to the consulate, receive the travel documents, etc. We interview them. Or sometimes, well, we're supposed to get consular notification. But between the time that the child has been detained to the child that is at Children's Village or something, there's like no communication at all. And that's what we're trying to work. We're trying to actually try to meet with lawyers from legal aid society.
We've been trying to organize
because we are interested in this, and we really, I mean, they're unaccompanied minors, so they're Mexican.
Yeah. I was at a all-day meeting with your First Lady in Chicago on exactly this issue a few months ago, and it was a tremendous interest in her government to improve the practices. It's similar with the Guatemalan government. I think there really is a genuine interest to try and create a more seamless process on all fronts.
Do you have colleagues in the other consular offices, the consul general offices in New York, that kind of do the same kind of work that you meet with regularly? I'm wondering if it would make sense to do kind of a bigger type of meeting.
There should. There's a group called CLAGMI, which is the consulate, the coalition of Latin American consulate in New York. But it's more for migration, but not for migrants. It's more for like general. It should be more specific. So.
Well, we met with the Guatemalan consulate, the consul general, and he is very interested in these issues, and he's trying to organize and he's going to reach out to the different consulates here to deal with this issue.
I have another question, Carmen, that I'm really disappointed with this prosecutorial discretion policy that Judge mentioned, because it seems to me that if the government is to exercise prosecutorial discretion, they should exercise in the case of unaccompanied minors. And it's like really disappointing to hear that they're not doing it more often. And I wonder whether, there isn't, it would sort of be, that one should sort of publicize it more, or what way pressure on DHS, despite this sort of DREAM Act policy, that even kids who haven't come when, who don't fit that criteria should be looked at really seriously, considered for prosecutorial discretion. Because to me, that's, at least for now, it's an out. It's a way of allowing these kids to go to school and, reunite with their families and continue living here rather than be deported. Do you have any sense of what is happening?
I agree with you 100%, and I have some suspicions. Again, this is anecdotal. I mean, I don't have any evidence of it. That with respect to unaccompanied minors, when they consider prosecutorial discretion, a negative factor that plays in is the fact that they don't want to encourage the parents or the family people from bringing the kids in, so they don't want to make it too easy. That's just my suspicion, because I've seen it, let's say, in Master County, there are other cases, adults, and same country, let's pick Guatemala or Salvador, and certain factors are present. You would think that if you have the same similar factors for a child, and then the child has been denied prosecutorial discretion, and there's no criminal record, there's no other adverse factors. The only one that I can think of is that I sense that it's a reluctance to make it too easy, or appear to make it too easy, or encourage the parents to bring their kids. Now let's be honest, that's the other side of the coin, that there's a tension here, a policy tension. You don't, if parents should bring their kids, and they're making decisions that are not in the best interest of the child by agreeing to do that, either pay smugglers or have somebody else bring the kids in, that's also a valid concern, because the parents, they really want to see the kids, they want to be reunited with the kids, and they're willing to put the kids at all these risks. Recently, maybe it was like a year ago, there was a program, I think it was an HBO, it was called Going Home or something like that.
Which Way Home?
The train, the
Right.
Way Home, Which Way Home?
Right.
And the kids on the train, I mean, I found that very, very weird. I mean, that was so realistic. I mean, I don't know, hearing it in Spanish directly, maybe in the translation you lost a little bit of it, but hearing these kids, expressing themselves and what they're going through. And that's the problem, that a lot of the parents or family members don't appreciate the dangers, and they're willing to send the kids. So that's another counter force that's here, an undercurrent that's saying, well, you know what, it shouldn't be that easy, because if it is, then when kids will come, there will be more risk. I don't know the answer. That's a really tough question.
I mean, the risks are unbelievable. I don't know if this still exists, but there used to be a shelter along the border just for kids who've been, decapitated because of train injuries. So it's really awful. Yeah.
I was wondering if there were other countries that you've looked to as models for dealing with unaccompanied children. They might have different policies.
I think you'd have to shop for a little piece here and a little piece there.
Okay.
I don't think
Specific
anybody's
policies.
I don't think anybody's doing it perfectly, to be perfectly honest. And when I first started, I had a very interesting call from some advocates in the UK, and they had been advised to talk to their American counterparts, because they said, we hear you're doing it well in the US, and as they asked me questions and I was answering, they said, well, maybe we'll call Australia. you know, I think it's an imperfect picture regardless of where you're at. But having said that, wouldn't it be nice to bring countries together and identify best practices in each country and see if we can bring all of that together?
That has never happened.
Well, there have been, you know, there was a study done in Europe a few years ago on separated children that Save the Children and UNHCR did together. But it's probably a little outdated at this point because policies have changed in a lot of European countries. So there has been some effort, but it's probably time.
I'm laughing because we've just been through a process with the ABA of kind of writing detention standards for civil detention. And we started off very, we started off very kind of optimistic about, you know, other countries as well. And there's not great models in other places. I mean, it's, you know, this is an area where I have seen those reports. I know that those meetings have taken place between NGOs in Europe and the U.S., but I'm not sure that there's great models. It might be worth doing a session just on this issue, kind of from an international perspective, though, to look at that.
And UNHCR has really come forward in the face of this recent influx and is very interested in playing leadership on this issue. And they could be very helpful.
Yes, please.
Hi, I'm Krista Stewart. I actually work for New York State on the Unaccompanied project.
You're the person I was talking about before.
So thanks for that. But actually, similar to that question and what Judge Videla had raised earlier, are there any good models that kind of converge the state and federal custody issues? I mean, I think there's a major disconnect between those systems within the family court, and sort of the issue always seems to be a jurisdictional argument that each camp will make that, you know, they don't actually each take responsibility. But are there other states that we could look to for guidance in that?
The whole SIJ process I actually think is challenging because you do have to do the family court process, process, and you know, off the top of my head, I know of our 7 sites, each of them has its own kind of peculiarities that it has to deal with in the family court system. So I'm having a hard time saying yes, this is the state to follow. Not really.
Well, it makes us feel better.
Yeah.
Why don't we take just one or two more questions and then have some closing comments because we're almost up at 4 o'clock, up against 4.
Luis Argueta. I have a question. You talk about a regional dialogue. How about an interagency dialogue here?
Mm-hmm.
And my other question is, are there any statistics about where these kids are, when we say the influx has increased, is it because they were caught at the point of entry after how many years being here? And the last question, is there any numbers on how many are deported versus how many obtain relief?
The influx, it's basically new arrivals for the most part. And in terms of interagency work, there actually is now regular meetings being hosted by the White House among the various federal agencies that have involvement with the Unaccompanied Children's Program. So that kind of dialogue at least is starting. I think it's hard though, and this is not just unaccompanied kids, I think of the immigration system generally, the functions are so dispersed across so many federal agencies, it is really hard to get, you know, kind of agreement on what should be done and anything moving forward from that point forward. You get into, you know, kind of mandate issues, turf issues, resource issues, different priorities, and it's a quick way to get bogged down in Washington is just disperse everything across different agencies. So I think we've got a little bit of that going on, but at least there's not.
Any final comments, Wendy or Judge?
Thank you.
Final questions? Thanks very much to everybody who spoke. We really appreciate it. It was a great session. Thank you.